Hi, this is Irina Shea, and this is part of our Wealth and Wisdom video series. Today, we're going to talk about what if my children don't get along in the context of estate planning. So, I'm going to share my screen with some thoughts. Okay. Look, families have all different dynamics, and often adult children don't get along, or they're simply not that close, or they live geographically far apart. They're not necessarily part of one another's lives. So, where does this show up in an estate plan most commonly is when you're selecting executors, trustees, power of attorney, and healthcare representatives. Okay. So we talk about in our office with any given family first about their family dynamics. So we have a context for making the best possible decisions about the estate plan itself and the fiduciaries who are going to be carrying it out. So um, in a family where, say, three children are all getting along and we want to allocate among those three children those jobs. So it could be co-executor or power of attorney as an or, um, things like that. But when the children don't really get along with each other, you're definitely going to want to instead go A, then B, then C. Because if you try to lock them together into group decision making, it's going to be majority rules. It could be a disaster needing mediation, arbitration, or litigation, right? You do not want to lock people into important decisions who already have demonstrated that they don't do it well, right? So, fortunately or unfortunately, it's probably better if you name one at a time. And each of these jobs has sort of a skill set, right? So, executor, trustee, power of attorney is going to be your financial child, we'll call it, right? That child who's responsible with money, on top of things, gets things done. The healthcare representative could be someone in the medical field. It is not necessary, or a local child, boots on the ground, right? Boots on the ground. It could be that. So you could still mix and match the jobs, but you're just not going to make them joint jobs. Okay. If things are really bad, and we have seen these situations where the siblings don't speak to one another, only fight, and trouble is brewing, right? Trouble brewing, meaning future litigation. What do we do? Okay. This is where we bring in a neutral fiduciary. What is that? Okay. This is typically attorney, accountant, or bank trust company. So if you're leaving your estate in three equal shares to three children, that's fine. But if they're going to squabble over the sales price of the house or the liquidation of any given asset, or, they would fight over whether the sky is blue, don't do it. Name a professional. So there are bank trust companies that are regional. There are bank trust companies that are national. Look for one of those and put in place a neutral. So a bank can be a great neutral as an executor trustee. They don't solve for power of attorney or healthcare representative. No go. So it doesn't solve everything, but even if you get those bigger jobs allocated to a neutral, maybe that is going to be your answer. So hopefully this has given you some solutions in case you find yourself in this situation. And if you do want to learn more, you can go to our website at irinashea.com, click on the Get Started tab. There is no charge for our initial consultations. Thank you.